if someone was interested in probably having living care as they grow older and their care needs change and increase, if that was their preference, how do they build a care preference into their LPA to ensure that by and large those preferences are met and respected?
Yeah, so I actively encourage this with every family I meet or every client for exactly that. So if they have particular wishes about receiving care at home, which I would say 90% of my clients and families I help say that, then to carve that clearly into the LPA itself, because it records the wish. It doesn't mean that it stops attorneys from finding a residential care or nursing home. What it means is that it makes it very clear what the person making the LPA would want, and it helps to reduce disputes.
Welcome, Sarah. Hello. And welcome to the Carecast. Nice to see you.
You too. Thank you for having me.
Tell us where you're from. You're from Renaissance Legal, Sarah, but what role do you do?
My sister at Renaissance Legal, we are effectively a boutique private client firm. So we offer everything from wills, trusts, powers of attorney, planning for the future, and then dealing with estate administration, trust administration, and all those things that come with it. My role and specialism is all about mental capacity. So I'm really passionate about powers of attorney and court protection, and particularly empowering people going through those processes and adding to their decision-making freedom so that if they can't make choices anymore, they've got the people they want to do it for them.
For someone that doesn't know, how could someone be passionate about the power of attorney? It's just a boring old legal document, isn't it? That doesn't have any impact on anyone's lives. There's no. What would
Lawyer word and legend. So, in terms of being passionate about powers of attorney, if you can be, it's
No, I think
because
you can be actually, but because of the huge impact getting it wrong must have on families, but
exactly that.
or
There's
not.
the biggest misconception I come across about this is that it's filling in a form. If I had £1 for every time someone says to me that you can just go online, get the forms, fill them in, send them off, job done, don't need to pay anybody to do it, don't need to ask a lawyer, don't need, you can just Google it or AI these days.
Yeah.
Which is not necessarily untrue, but these documents are giving the authority to people that you trust to do everything as if they were you, or at least broadly. So all of your money, your home, your income, your finances, where you live, who you live with, how you're looked after, what medical treatment you do or don't receive, and so on. And it's not just choosing people, but also choosing how those people make decisions for you, in what way, at what time, what happens if one of them is no longer available, who subs in, and again, what does that look? Because these two people might work really well together, but do these two people, and so on. So it's all about building really bespoke, genuinely meaningful legal documents, not just filling in a form, which, as you've touched on, can lead to horrendous problems later.
And this is all in the event that someone loses capacity. What does it mean to lose capacity, Sarah?
So mental capacity is very decision specific. It's not a blanket or a binary concept. It's not the case that someone has capacity or doesn't have capacity to do
Unless
something.
you're in a coma, probably.
Well, exactly that. Yeah, unless there's something.
One end of the spectrum, if you're in a coma, you don't have capacity.
Yeah, exactly that. But it doesn't necessarily mean that you won't ever have it again, for example. And you might have situations where you have mental capacity for something, but not something else. So, for example, you may well have mental capacity to decide who you want to look after your money. You may have insight into the fact that you struggle a bit with dealing with your affairs or you need a bit of support. Let's say you've got some additional needs. However, you might not have mental capacity to go out and do your shopping without support. So you might have capacity to make a legal document, but not do the thing that the legal document is asking. It's the same with like making a will, for instance. You might well not know who the Prime Minister is, but you may well know exactly who you want in your will and what you want it to say. So in terms of how mental capacity applies and losing it or gaining it, It's actually much more, if I can put it this way, like on a spectrum, and it can fluctuate as well. So anybody who takes a blanket approach or takes an attitude to a capacity assessment of ticking a box needs to get out the door.
Sarah, what are the different types of power of attorney in the UK, and what do each of them cover?
There's actually kind of three. So I'll start with what we call general powers of attorney, sometimes called ordinary powers of attorney, sometimes called a Section 10 power of attorney. So anyway, that document under its various guises is something that when you have capacity, you can appoint an attorney or attorneys to do things on your behalf. Broadly, those don't remain in effect when you've lost mental capacity to deal with things or make particular decisions. So there's one that sometimes gets overlooked and is well worth considering. There's enduring powers of attorney, which if they've already been made are still valid, but you can't make a new enduring power of attorney. They stopped being legally valid to be created when lasting powers of attorney came in. So what you might find is that there are still enduring powers of attorney knocking around, and they're still valid as long as they were prepared correctly. You have ordinary or general powers of attorney, which are broadly used when someone still has capacity, and then lasting powers of attorney, which are the most common one that you come across now. They have been in place since 2007, I believe it was. And those enable you to nominate attorneys, people that you trust to make decisions on your behalf if you can't make them anymore or you need support in making them. And those are centrally registered with the Office of the Public Guardian, the OPG, and they then are legally valid documents to allow people, your attorneys, to do things on your behalf.
Why would someone want to have a power of attorney to set one up? What are the main reasons?
Lots of people put them in place for future proofing. So a bit like you and I chatting today, we can make our own decisions. We know what we want to do and how we need to do it. But I have them in place currently because in the future, something might happen to me, which means I can't look after my affairs. Most people, when I'm having these discussions, will refer to losing their marbles. So when I get a bit older, need to think about powers of attorney. But actually, I help clients of all ages with powers of attorney and decision-making related issues because anything can happen. It could be an illness. It could be being in an accident that thankfully doesn't kill you off, but it leaves you disabled or less able or less capable. And very often they are put in place for future proofing so that if something disastrous happens, the people you've chosen will look after your affairs and make decisions for you. And it's not left in the hands of the local authority, the NHS, the government generally, the banks, etc. It gives you that decision-making power.
Just the smaller side, if someone was young and they had an accident and they had a house and assets and various sort of things that needed help, that needed to have decisions made, is it who would then be making those decisions in the absence of a power of attorney?
That's a really great question. So in terms of dealing with the finances in someone's house, typically that will require, in the absence of the person having mental capacity or even physical ability actually, and in the absence of an LPA being in place, to deal with money and property, broadly speaking, would require an application to the Court of Protection. So that fills that power of attorney gap. In terms of health and welfare decisions, so health is the obvious one, going to the doctor or the hospital, but welfare covers everything from where you live, who you live with, the type of care you receive, even right down to your nutrition. Those decisions, if there isn't a health and welfare LPA in place or any other suitable power of attorney, then the professionals in your life and in fact, everybody in your life who is making decisions on your behalf are required to follow the best interests framework, which is underpinned by the law. So essentially, we are all required by the Mental Capacity Act to, when making decisions on behalf of somebody else, to make those decisions in their best interests. That's the key principle. Applications are sometimes made to the Court of Protection where there isn't a health and welfare LPA and where the person doesn't have capacity, because there might be some sort of dispute or issue and that's hit an impasse and it needs an independent judicial opinion. And occasionally you would have a deputyship put in place for what they refer to as personal welfare. It covers health and welfare. I could do a whole interview on just that alone, but I hope that gives a helpful overview.
Yeah, no, it does. And just briefly, what are the cost and time implications of having to go to the Court of Protection? How long will it typically take to get financial power of attorney, and what does it cost people?
In terms of applications to the Court of Protection, I'll start with timescale first. That varies really quite enormously. The court has a big backlog and they have a lot of applications on a daily basis. They are working really hard on their processing times. But in a nutshell, it could take anywhere from several weeks to several months to beyond a year to get a decision. It depends massively on how complicated or straightforward the application is and the circumstances are, if there's any element of urgency, how complex it is, and how many people are involved. So if it's a case of you're applying for your grandmother, for example, and there aren't really any other family members, and it's really simple, that's likely to go through a lot quicker than a contested, tricky, complicated application. So that's timescale. And then in terms of costs, so the court has an application fee, which is currently £421. Don't ask me where they get the number from. And then in terms of paying a lawyer, it depends again massively on the application, which isn't me being woolly. It's just that the amount of work it takes really will depend on the case. I can't give a concrete answer that would really be meaningful for people. But what I would always say is to always get quotes and explore people's experience. Because if you've got a solicitor or a lawyer or someone representing you who's having a go, the outcome is going to be very different to someone who deals in Court of Protection and mental capacity all the time. So I would always say, go follow the experience and the expertise rather than the price point if you can.
Yeah. I presume that the cost probably would go to even tens of thousands or hundreds of thousands at various times, depending on how complicated things are. It wouldn't be that unusual, really, would it?
Yeah, you'd be very lucky to go north of 5 figures, I would say. Unlucky to be north of 5 figures. That would be, I don't see that typically, although I have to say a lot of my work isn't contentious. So perhaps from that perspective, it would be. But yes, It's certainly, depending on what it is and how complex and etc., it can run into thousands, yeah. But again, it all comes down to having the right person representing you, managing your expectations, and also dealing with prospects of success. The amount of times that I advise clients and families who are thinking of making certain applications, I'm always absolutely transparent about prospects of success so that we don't pursue a very expensive process that might not get the right outcome. So that's also really crucial. If you have someone who goes, yes, I'll do that application for you and here's the bill, then I'd always be a bit wary.
What are the key differences, Sarah, between a lasting power of attorney, LPA, and an ordinary power of attorney, an OPA?
Yeah, so from a basic perspective, it's the documents are much smaller and simpler when you compare them to one another. Ordinary powers of attorney are broadly put in place by people with the purpose of having somebody authorised to do something for them while they've still got mental capacity. And typically they're tailored to particular reasons. So it might be operating a business, looking after a rental property or a portfolio. It can be general and very broad, but usually they're in place for a certain reason or range of reasons. The other thing, the key feature of it is that generally an ordinary power of attorney or a general power of attorney is capacity limited. So if you lose the ability to make the decisions covered by that power of attorney independently, then typically that ordinary power of attorney will end. In contrast to lasting powers of attorney, as we mentioned earlier on in a different question, lasting powers of attorney are lasting. They are put in place unless and until you withdraw them. They can't be used, for example, if everybody under the LPA can't act anymore, or you make a fresh one. And they can be used, certainly the financial one, you have the option of saying, I want to be able to ask my attorneys to help me, even if I've got capacity and I can do things myself. As well as if you lose mental capacity or the physical ability to do things, then your attorneys can help. So ordinary powers are broadly for when you have mental capacity, and they're usually more narrow. Lasting powers of attorney are broad and they are long lasting.
Yeah. Just looking at the word attorney, actually, do you think they made a mistake using that word, which can sometimes be interchanged with the word lawyer or solicitor, attorney, and then to use the word attorney where someone who isn't professionally qualified can step in and act as an attorney for someone? Has that led to a lot of confusion that sort of hasn't really helped the uptake of powers of attorney, or am I off the
It's a really interesting question. I have to say, I think that the language surrounding all of these things in general is very confusing. And it is often used interchangeably because it's hard to keep up. So, you have the Court of Protection, you have the Office of the Public Guardian, you have lasting powers of attorney, and an attorney, as you say, is another word for a lawyer overseas. And then you have deputyship, and a deputy and an attorney have very similar roles, but they're not the same. And I think generally the language around all of this can be quite confusing. So I have to say the specific point, though, about an attorney and getting that confused with a lawyer, it's not something I typically come across. It's more
I think it's
that the
we've watched
language
really
in
American
general.
films and all that does it, but
Yeah.
it's not an English term for lawyer or solicitor, really, is it? But having watched
No, it's not something we use typically. So I have to say, I don't often have that problem. But certainly, as I say, in a general sense, the language can be pretty confusing for people and quite interchangeable.
who can be appointed as an attorney, Sarah, and what are the responsibilities that come with that role?
So anybody who's an adult can be an attorney as a starting point. Very commonly, I get asked if children or teenagers can be put on in advance of them turning 18. And the answer is no. You have to be 18 already in order to be an attorney and to be appointed. And in terms of the other key headline characteristics is you need to have mental capacity. So if you don't know what you're doing on a day-to-day basis, you're probably not going to be a very good attorney. And the other thing for the financial one is that if you are bankrupt or subject to a debt relief order, then you wouldn't be eligible to be a financial attorney. But beyond that, you can choose trusted family members, dear friends. You could even have professionals as well, or as replacements or instead. In terms of responsibilities of being an attorney, they are absolutely enormous. Because attorneys are stepping into the shoes of somebody else. So if I became your attorney, I would be responsible for making sure that your home, your bank account, your finances, your well-being, everything is looked after the way you would want it to be looked after. And I'd be meeting your best interests. And that's alongside having my own life and my own day job. So in terms of responsibilities, it's a real privilege to be an attorney for someone. And it's something that should be taken very seriously. And in terms of who you appoint, then it's really important not to think about the label of the person, but how suitable they are to do the role. So I met a lovely couple who had 3 sons, and they said, we'll have all 3 as attorneys. And when I was talking to them very candidly about family life, etc., it was very clear that one of the sons would be totally unsuitable. Nothing against him personally, but as an attorney, he would not be suitable. And we had a really crucial discussion about the fact that the attorney is who's best for the role, not who they are in relation to you.
So obviously, a professional attorney will be paid for their time, as they should be, and they have to be. But what are the rights and wrongs around, say, a friend or a family member being recompensed for the time that they've spent managing someone's affairs? And it could be a lot of time. What do people generally say about that?
Absolutely. And it's something that often gets overlooked, actually. And it's really important because, as you say, the amount of time that an attorney can put into looking after someone's affairs can be massive, especially if they're doing that alongside childcare, their own life, their own job. So attorneys are entitled to be reimbursed for reasonable out-of-pocket expenses. So if you genuinely take the person you're attorney for somewhere and you pay for all the fuel and some food and the parking, it's reasonable to be reimbursed. And the key is keeping really clear records, because then you know that you can sleep at night not worrying about it. In terms of being paid for time, so taking half a day off work to go and help you with your affairs as an attorney, you're not automatically entitled to be paid your half day rate because you're an attorney. However, what you can do when you're making your LPA, and this is where another reason it's not just a form filling exercise, and it's always a good idea to get good advice, is you can build what you would like your attorneys to be entitled to into the document. So you could express wishes about what you would like them to be paid and on what basis. If it's too vague, then your attorney will run into problems. If it's too specific, it might be too narrow for your attorney to benefit. So it comes from a really helpful, in-depth discussion with your lawyer or your advisor. And it may be that the attorneys can look to the Court of Protection for a certain financial benefit. And when I say that, I mean a reimbursement for time and work done. But if at all possible, you'd want your attorneys to avoid an application to the court because it takes a very long time, it's very expensive, and it's stressful. You know, a court application is stressful, even if it's quite straightforward. So that's what I would say in a nutshell, is that non-professional attorneys can be reimbursed for their reasonable out-of-pocket expenses. And it's a really good idea for people making their LPA to think about how they might like their attorneys to be compensated for time that they spend, and to take advice on how best to achieve it.
Is that something that you will typically cover in a new client's LPA as a matter
So
of...
I would always touch on this point because it's something that people go, oh, and it's really important, especially when it comes to settling disputes. And it also helps my clients, the people that I help, to go back to their families, loved ones, attorneys, and remind them that their powers are limited to best interests, and those fall on what we call the donor, the person making the LPA. So they might be presuming, oh yeah, I'll be an attorney for mum and dad because I can pay myself if I need to take time off, not in a bad way, but just genuinely not realizing that there are rules surrounding all of this, which are all safeguarding rules to protect people from financial abuse, basically.
For someone listening to what we're talking about now, if they thought, I'm going to get it done today, I'm going to pick up the phone, I'm going to call you, what is the process for creating and registering a lasting power of attorney? How long would that bit typically take? And more or less, how much would it cost?
Yeah, okay. If we took a call here at Renaissance Legal, for example, we'd get an appointment booked in so that me or one of my lovely colleagues would meet with you, find out what it is that you want to achieve, see if there's anybody in your family who is vulnerable, for example, or certain provisions that you would want to be recorded in your LPA. And it's amazing how many people start the meeting saying, oh, we just want each other and our two kids. And then by the end, we've got a really bespoke, tailored, personalized document, which gives them so much peace of mind. It's a privilege. It's why I really enjoy the work. Taking something and shaping it for those clients and making it last as long as possible so they don't have to keep coming back, making a new document every few years or whatever.
That might be a series of meetings, say 2 or 3 meetings or more.
Yeah, so typically what I find is that I'll have my first meeting with the clients or the family and get the ball rolling. Typically then, unless they're very firm on what their wishes and instructions are, I'll send a little follow-up for them to go away and think about it all over a cup of tea. They'll come back to me with, right, Sarah, this is what we want. We've made up our mind about A, B, and C. I'll draft the documents. They'll go through them, and subject to them all being, signed and dated, they go off to the Office of the Public Guardian to be registered, which makes them valid and legally usable. So that whole process from meeting me at the very beginning to sending the documents that are signed off to the Office of the Public Guardian depends really on the family and how much time it takes them to pin down what they really want. But I would say allow a few weeks from the first meeting to pinning down your wishes and getting them signed. And then from a registration perspective, it typically takes 2 to 3 months on the whole, from the OPG getting the documents to sending them back. So give yourself, if you started the process in January, you would absolutely hope to have your documents by June. But some people take a very long time. It can be very challenging to pin your wishes down. And very often people will start and then get stuck on the difficult decisions and not move forward. And that's, again, where a lawyer having you chivying you along a little bit to get it sorted is really helpful. Because if you get the forms off the internet, you get halfway and you give up, then there's nothing in place. And that can be disastrous.
For the average family, what sort of fees would we be thinking about?
So we offer fixed fees for LPAs, and we also offer packages. So if people come to us for wills or to make a trust or any of the above, we'll always adjust the prices accordingly to make it achievable. But just as our headline fixed fees for LPAs at the moment, if you are an individual coming to make property and finances and health and welfare LPAs, it's $1,100 plus VAT. That's from the very beginning to picking up the phone to having the documents in your hand at the end. And then for a couple who are making mirror documents, that would be $1,350 plus VAT. And same again, it would be from picking up the phone to having the final documents in your hand, done and dusted.
Thank you. Bit of a side question. I was thinking, what would happen if you got your LPA done and it was in the process of being registered? If someone were to lose capacity during the gap between sending it to the Office of Public Guardian to actually the final registration, do they have any sort of fast track process to prioritise certain applications over others in the event that it's really needed, or is that just not a thing?
Yeah, so there isn't a specific fast track, but there is just a natural ability to let the Office of the Public Guardian know that it's urgent. So let's say, for instance, the LPA is pending registration and there's a house sale going through and it's needed for exchange and completion. You'd get straight onto the Office of the Public Guardian by phone, explain the circumstances, and they would do all they can to get it processed sooner. If there isn't a genuine urgency, because urgent means different things to different people, then it will take that bit longer. So if it's just a case of, oh, my grandmother or my mum or somebody has lost capacity and we need it now, but actually they don't, or it can wait for another few weeks until it comes back, then you will probably not jump the queue.
So there's some ability to prioritise?
Yeah, there's breathing room for priority for urgent need, yeah.
Sarah, what are the common misconceptions or myths around power of attorneys that you come across all the time?
So there's 3 headliners. The first one is that it's just a form filling exercise. I've touched on this in other answers. It's not just form filling. These are very important bespoke documents. So that's probably the biggest one. The second one is timing. People thinking they don't need to worry about it now. I'm in good health, so I don't need an LPA. I'll worry about it when I'm older or when I start losing capacity. That's what people often say. And I always point out to them that none of us are indestructible and we could be in a life-changing accident, get a life-changing diagnosis. Anything could happen.
One thing that you can't do once you've lost capacity is to make an LPA, right?
Exactly. If you can't do it anymore, you're in a real pickle. And as importantly, the people around you, your loved ones, will really struggle as well. And then the third sort of common one is that you don't need an LPA because my husband, wife, whoever can just pick it up for me. We're married, that they can just do it as my husband or my wife or my spouse. Occasionally people think their children can as well. And then when I point out what a disaster that would be if it was that easy, it then soon unravels that LPAs are a very, very good idea.
One thing that we notice when a new client comes to us, and there might be 2 brothers and 3 sisters involved with trying to source care for their mum and or dad, is that there can be very variable opinions on what the best form of care is for their parent or the best course of action. If someone was interested in probably having living care as they grow older and their care needs change and increase, if that was their preference, how do they build a care preference into their LPA to ensure that by and large those preferences are met and respected?
Yeah, so I actively encourage this with every family I meet or every client for exactly that. So if they have particular wishes about receiving care at home, which I would say 90% of my clients and families I help say that, then to carve that clearly into the LPA itself, because it records the wish. It doesn't mean that it stops attorneys from finding a residential care or nursing home. What it means is that it makes it very clear what the person making the LPA would want. And it helps to reduce disputes with the local authority, who might try and pop your loved one wherever it suits them and however cheaply it may be.
Or between
And also,
siblings, or between siblings, most probably the parents really don't want their siblings to fall out after they've lost capacity or
exactly
after
that.
they've gone.
Exactly that.
And often
Yeah.
we see it starts triggering the fallout. But sorry, carry on.
Yeah, that's exactly what I was going to say. If it's not the local authority you're battling, you might have it on quite literally a home front where you've got siblings or people who all have good intentions and are well-meaning for mum, dad, the loved one, and having it very clearly in the LPA what is wanted and what's not wanted means that it just reduces the risk of a big dispute happening between siblings, family members. And as we all know, there's nothing like family, and especially when money becomes involved as well.
No, absolutely. From a solicitor's perspective, what advice would you give to families who are considering living care for their loved one, and what legal frameworks should they have in place with reference to, say, powers of attorney?
Yeah, having powers of attorney in place is really crucial. It will help with all of the decision making that goes along with live-in care, and you can also look at safeguarding issues within that process as well. So I would say the headliner is thinking about powers of attorney and mental capacity and making sure that all the decision making authority is in place that's needed for your loved one, or if it's you thinking about your own live-in care. So that's number one. And then number two would probably be, as I've touched on, safeguarding. So thinking about things that are in place to make sure that your loved one is getting the right care. So going with a reputable CQC accredited provider with a good reputation, good reviews. And also the other thing I'd really encourage families to do is to seek advice where they're able to about things like their loved one's rights under the Care Act and associated law, and policies, so local authority policies, and also considering NHS continuing healthcare funding and whether that has any interplay with the care they receive at home. And even if it's topping up things like continence resources or walking aids, things like that might come from the NHS as opposed to social care. So I'd recommend getting advice on all those points as well.
Thank you. Sarah, where can listeners find out more about powers of attorney in general, but also your service that you offer at Renaissance Legal?
I would always encourage anybody who is Googling or going on AI to help them with this, please use the gov.uk website as your starting point. There are loads and loads of blogs, forums, websites, solicitors' firms, etc., and so forth, with tons of information But the OPG, the Office of the Public Guardian, their guidance and regulations and forms and documents are on the Gov UK website. So if you want to do it that way, please use the official site. In terms of taking legal advice, which I urge everybody to do, they really are important documents. Whether you come to Renaissance Legal or not, I just really encourage people to get qualified, experienced, tailored advice. And if you'd like that from Renaissance Legal, then we have lots of resources on our website all about powers of attorney. We run free, completely no obligation, and they are anonymous as well, webinars, information webinars about decision making. So powers of attorney and court of protection, and also about other things as well, welfare benefits, entitlements, and wills and trusts and planning for the future in that way. So they are completely free and complimentary. Loads of information on our website. And actually, you can just give us a ring. Sometimes you just want to talk to somebody, talk to a human and get a straight answer to a straight question about powers of attorney or whatever it might be. And we've got, I would say this, wouldn't I, but a fabulous team who take care of clients at that initial inquiry point as well.
Amazing. Thank you, Sarah. I really think this will have been helpful to some of our listeners to encourage them to get their power of attorney and to, or maybe to refresh it. But really do appreciate your time, Sarah. Thank you, and lovely to meet you.
Thank you for having me. It's a pleasure.
Thanks very much, everyone, and we will see you again very soon. All the best.
Thank you.
Bye-bye.